Alex here with part 219 of the Docket series on child custody and visitation. As for my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex-parental rights have been terminated. Number two, the nutshell version as to the purpose of the series, to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into the judge's order granting my motion for costs following the second appeal. My mindset was still annoyed, but relieved that she wasn't going to make yet another mistake. She does end up granting the costs that I requested for both appeals. It's not really one of those videos where I have a whole lot more to say during the mindset portion than other than I got what I wanted and it felt good to get what I wanted. And so why don't we just go straight into what the judge has filed. Here we have the judge's order granting motion for costs on appeal. Standard introductory paragraph indicates the court's reviewed my motion for costs on appeal submitted to the court May 23rd, 2018, and orders as follows. Number one, first paragraph anyway, is the Nevada Court of Appeals issued its order of reversal on April 24th, 2018, stating that pursuant to the law, two cases, that an award of costs is mandatory in this circumstance. In accordance with the April order, the court vacates the portion of the June 24, 2017 order that denies my request for $250 in fees, and I am hereby awarded $250 in costs incurred for that appeal, stated in my memorandum of costs, and an additional $250 in costs incurred for the subsequent appeal, stated in my March 28, 2018 memorandum of costs, for a total award in the amount of $500. Certificate of electronic service under Rule 5. Oh, she doesn't mention the rule. Oh, here it is. Yeah. Certificate of mailing under Rule 5. She's indicating this document was mailed to my ex. Next document. We have the notice of entry of order. This is what triggers the timeline for my ex filing an appeal if she would want to. She doesn't file one. In any event, if you want to learn more about the notice of entry of order, please watch my video on the topic, notice of entry of order. So I filed a motion for costs. The court has disposed of that motion by granting it. She also vacated the prior order that she denied and granted that one as well. So that's where I ended up getting the $500 in costs from. Going into the aftermath, I filed one document, but it was a free filing, so I incurred $0 in costs. My ex didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex didn't have an attorney either, so she incurred $0 in attorney fees as well. As with my previous videos, I'll take this opportunity to feel free to post any questions you have down in the comments below, and I will see you guys next time.